All right, ladies and gentlemen, we'll go ahead and call the first Revenue Committee meeting of the 2024 budget session to order. I'm been told I have to tell you about their committee rules of decorum. Copies of the decorum rules are located with hard copies of the agenda and are available for view on the legislative website on the page for this meeting. And we note that these rules at the beginning of each meeting simply as a reminder that we expect everyone in attendance to be treated in a courteous and respectful manner. Please address the chair and refrain from debating committee members. We'll just talk through the chair like we always do, and I appreciate you guys. First bill and only bill up for consideration today is Senate File. Oh yes, we better do a roll call. Thank you, Mr. French, Senator French. I got ahead of myself. Let's call
Senator French,
Here.
Senator Ide,
Here.
Senator McCohen,
Here.
Senator Pappas. Here. Chairman Beitman.
Here. Okay, now that we got that out of the way. Senate File 55, Board of Equalization, questions before the board. Take it away, sir. Introduce yourself and walk us through this good little bill.
Good afternoon, Mr. Chairman and members of the committee. My name is Marty Hartzog. I'm Chairman of the Board of Equalization. With me is our board member this year, Jane Mockler, and I say this year because it kind of rotates around every 2 years, so it's just an administrative title, but it's a pleasure to be here before you. You might recall I sat with you all, I think, back in September, October, up in Casper to talk about this bill. And before I get started, I just want to lay out a reduction of what this bill does. And if anybody ever tries to convince you that it does any more than this, call them on it. And I'm happy to sit down and present the materials that I gave you. You should all have the materials that I originally provided, which gives you a whole little history. Happy to do it again. This bill simply clarifies that the board has the authority that it always had before a particular ruling. And that is, we are permitted and empowered to consider the entire law. All of the statutes, all of the rules, the arguments that come with them. And so what happens is if the parties come before us, and it happens, it's not taking a shot at the parties, but sometimes they miss something, especially on the mineral side. It can be fairly complicated. If they miss something in the statutes, the board has to be able to say, yeah, but what about this? We're literally going to direct your attention to something in the statute that you have not considered in your briefing, you haven't considered it in your case presentation, but we have to be able to look at that as well to get it right. I mean, we're a court after all. And what happened was we had a very interesting mineral taxation case, soda ash, and the parties came before us, the Department of Revenue and the taxpayer, arguing about a deduction. I'm very familiar with soda ash. I dealt with mineral taxes for 17 years at the Attorney General's office. I litigated before the board that I'm now on forever and ever. And so what happened is we as a board said, oh, wait a minute. You're arguing about this deduction, but under the valuation methodology at play, there's a question as to whether you get a deduction regardless. And so we had the parties brief it. We had them provide additional argument. We didn't make the decision without giving them a chance to respond. And we ended up ruling that they didn't have an issue. There was no additional deduction. And the taxpayer complained that procedurally we couldn't do that. And in a 3-2 decision at the Wyoming Supreme Court, they agreed. Now, I will tell you that I still struggle with how they came to that. The 2-judge minority nailed it and explained in fairly clear terms why we had to have the ability to look at the entire law. And since that ruling, there's been about 6 cases where we've had to drop a footnote in appeals before us, and we've had to say, look, the parties both missed this issue here, but we're not permitted to consider it as part of the analysis. And so we've had to basically, and I hate to say it this way, but it's true, we've had to decide which party was less wrong, which of course propagates an incorrect ruling of the law or an incorrect understanding of the law until finally the issue comes back around in another cycle. So the language in this bill, and I think where we got in trouble last year is it looks like it does something sneaky. Because you would ask yourself, why are you even having to do this? Why wouldn't you have this authority anyway? And that's exactly right. We did have the authority until this ruling in Solvay, which was the name of the taxpayer. So really, if you look at the language, it just simply says we have the ability to answer the question with respect to the law, irregardless of whether the taxpayer and the department, the parties have correctly identified all of the arguments. We can make sure that we look at everything and get it right. And I know that seems overly simplistic, but that's exactly what this bill does. It's just that simple. There's nothing else. I did sit down with the county assessors. They were all worried that, oh, you're gonna, do this and that and take over. No, we can't do it that way. When we deal with the county boards, we sit as an appellate court on a record review, which means we have to look at exactly what the county board decided. And if they got it wrong, we have to send it back to them to do it over or reconsider it, or we just decide they got it wrong. We don't get to take new arguments on appeal. In fact, when I think one of your co-committee members, Representative Oakley, I think, raised a question, I think that was her, and she raised a question as to whether we could do that at the county level. And she says, you can't raise new issues on appeal, which is 100% right. If somebody brings to us an argument in a county case that was not presented to the lower court, we literally have to say, too late, you cannot raise new issues on appeal. You didn't raise it below, it would be improper for us to allow you to sandbag, basically, and then ambush the parties with a brand new argument on appeal. The Wyoming Supreme Court doesn't allow it, District Court doesn't allow it on appeal up from lower bodies. And we don't allow it. So that fear that we could allow some kind of sandbagging and we could basically usurp the authority of the county boards of equalization never happens, never has happened, and we can't do it. We would end up sending it back if they did something fatal, like they didn't consider jurisdiction. We would say, well, didn't consider jurisdiction. In fact, we just did that this last year. They missed something, and we said, there's a jurisdictional question, but since you didn't answer that, deal with it at your level, we can't. So we sent the appeal back and we ordered the county board to address the facts that brought into question whether the parties had timely appealed. So that's a good example of how we would handle that. And with that, I don't know that I can tell you any more about this. It's quite straightforward and really that simple. Thank you.
Thank you, Mr. Hartog. Senator French has a question for you.
I was county commissioner for a long time up there in Park County. And when we started out, we would, the commissioners, we'd just hear it. And then if they appeal, make our decision. And then if they appealed it on down to the state Board of Equalization. And then we kind of, man, we need to do better here. So at that point, we hired our attorney, because the county attorney acts as the assessor's attorney. Mm-hmm. And so we had hired an attorney to do the statement of facts and conclusions of law, I think was what it was called, mm-hmm. And render our decision, and they could appeal it. But we felt that wasn't quite good enough. So as the years went by, we started recording everything, and the paper, everything is sent. If they appealed it, our decision and all the paperwork and everything down to you folks. So it was just a better deal for the taxpayer. But aside from that, if this passes, does it open the state Board of Equalization up to legal questions like, wait a minute, you kind of decided those things on your own, even though it may make sense, didn't have a chance to argue that. I mean, are we opening the state up? I'm having trouble spitting it out, but I think you get the gist of what I'm saying.
Mr. Hartog.
Mr. Chairman and Senator French, that's exactly what the fear I wanted to allay. And I did meet with all of the assessors on a conference call last week or the week before. And that question came up, and that's exactly what we can't do. If something comes up that they haven't considered, we're then presented with, well, what did the county board decide? And I look at my co-board members and I said, well, there's nothing in the record. They didn't consider this. And if it's important enough, if it's something that they needed to consider it, we would send it back. So what happened years ago, and I use this as an example with those folks, it happened this year too, but it was a county board, I won't say which one, and they basically just said, well, we don't think the taxpayer carried their burden, we fine for the assessor. But they didn't explain any reason why. They just said, you lose. And a number of times when I first came onto the board, there's case law on whether you can do that, and the answer is no. A deliberative body, a trial court has to explain with sufficient detail why it decides what it does. Otherwise, the appellate court, us, we're at a loss to understand why they decided what they did. We can't just affirm that or reverse that without knowing. And so in several cases in one particular board, we said, we know you ruled on so-and-so's behalf, but we have no idea why, so we can't judge whether it was correct. So we literally sent it back and said, you need to tell us why you decided this with sufficient detail. So there's one instance where we couldn't just rule and say they got it right. We would have to send it back. The one that I mentioned just a moment ago, it was jurisdictional, and there was a question as to whether the party who appealed it. They appealed something else, and then the county board kind of assumed that the appeal carried forward to another event. So when we got in there, the assessor said, hold on here, they didn't really appeal. But the county board below never answered that question. It was never raised ever before the county board. They raised that for the first time on appeal. And of course, we looked at that and said, well, it doesn't look like they've appealed, but we don't know what the county board would have decided. So we sent it back and we said, you need to determine whether there was a timely appeal, all the process of appealing by a certain date within 30 days of the final decision. And if they didn't, then you're going to need to either give them more time to appeal or dismiss for lack of jurisdiction, because you got to appeal within a deadline. And so there's another instance in which we didn't make the decision ourselves. We sent it back for the county board to make an initial determination on the timeliness of the appeal. And so really the answer to your question, no matter what, is if we don't have something before us in the record, we don't have authority to just kind of run with it and say, well, this is what you should have decided, so-and-so wins or so-and-so loses. Can't work that way. In fact, that would be reversible error. They could take that right up to the Wyoming District Court and the Wyoming Supreme Court and say, the state board didn't have authority to reach the decision they did because there was nothing below that they could point to affirm or reject. And then we're talking now strictly about county board rulings, right? So everything on that instance is we're looking at what the trial court, when you were the county board on the Board of Equalization below, what they decided in the first instance. And then, of course, just so you know, a lot of those same questions about who represents us, how do we get these things done, still come up. I spent about a half an hour with the county assessors kind of going over the different ways to get all that done. So that's something that county boards still struggle with in terms of getting assistance. Sure.
Senator Ide.
Thank you, Mr. Chairman. Just a quick question here. Marty, it's maybe just perception, but a lot of my constituents, including myself, you kind of wonder if the people are really getting justice, at the second level of appeal. The perception is it's just a rubber stamp. You know what I mean? That's what I talk to a lot of people, and they think, it goes to the county, and then, they send it to the state, and, nobody knows who that is, who's on that board. How often, is there sort of a broad number of how many you reject or accept, just so you can kind of get a pulse on how that works? Thank you.
Mr. Hartzog.
Mr. Chairman, Senator Ide, it's interesting. One of the, and just a couple of years ago, in fact, we were here and that question came up. There were a lot of upset folks, especially during the pandemic, and we had a full discussion on the things like presumption of correctness, the burden of proof, all of that, the fact that the taxpayer having no idea how mass appraisal works, which most don't, come in and they just feel like they just get ambushed. And the truth of the matter is, if you don't understand how your property is valued and you don't have an attorney, it's extremely difficult because you're oftentimes speaking a different language. And that's just there's just no other way to color it. And so I've actually heard taxpayers in argument say, well, I think you guys will just rubber stamp this anyway, so I don't have much hope of winning this, but, which is never a good strategy in argument. But nevertheless, it happens, and that's the perception. And all I can say is that the law provides the assessors with this ability to assess value, sometimes tens of thousands of properties each and every year, which of course is based on a statistical framework, which it makes it fairly difficult. They have all the tools to do this. They have, all of these really well-established mechanisms to do this. But for the person that just understands their bank loan and how that fee appraisal is done, and they look at the listings and they talk to their friend and they come in and they say, well, my friend, the realtor, said, well, that doesn't sound right. And the problem with that is it's just not going to hold up against a well-performed mass appraisal. And so what does happen is you're just most taxpayers are not going to be well equipped to really understand the mass appraisal. And hopefully the assessors sit down and really walk them through it, and most do. Your second question about how many have prevailed, I would say over the last 5-6 years, I would say the prevailing taxpayer on a valuation case, not exemption, because the exemption cases, the taxpayers do prevail quite often, not way more than on the valuation side. I would say it's probably less than 5% prevail on the valuation side. But the way you got to look at that is it should work that way. It should be rare that the taxpayer or that the assessor isn't getting it really, really correct. But again, I hate to say it, but they're speaking different languages for the most part. So it is an uphill battle for the taxpayer to prove that the assessor didn't get it right, which is their burden. So.
Any questions? I have one for you, Mr. Hartzog. So let's say this meets the similar demise that it always does. How does that affect you and how you're able to do your job? And you mentioned the footnotes that you're doing. Can you walk us through the consequences of not passing this bill?
Yeah, it's miserable. And we've had about 5 cases and usually in some pretty tough involved mineral tax cases where the parties they miss something important. And so we literally will, in fact, we're having hearings. Years ago, we had this very thing happen on a sales tax case. Wasn't a property tax but it was of course it was at the state level because sales tax is centrally assessed or state assessed. And we dropped a footnote, and it's a transportation deduction on a mineral well site, and we said neither party looked at the question of whether this was a transportation issue as defined in the statute. They just assumed. So they were both arguing about something which, from our perspective, we thought would be viewed very differently if they had. And so we dropped our footnote and we said, here's the problem. Both parties looked at this completely without looking at it from this perspective. This is pretty involved. It's not easy, but it's there. And so the ruling might be otherwise had you done so, but in light of how you presented it, we ruled basically which party was less wrong. So we have a ruling on the books and the parties then can go ahead. Well, of course, what happened then is one of the parties looked at that and said, oh, And of course, in state assessed taxes, there's always a cycle. The same case is going to come back almost every year, right? Because if it's a mineral taxpayer, they're here for 50 years and they're doing business in the state and the same question comes up. It's not usually a one-off. It just isn't. Everything mineral is always, you have dozens of producers and they're all doing something similar and there's an issue and it affects all of them. So the issue comes back up, and it did. And so now we have the hearing on the question that we raised. One of the taxpayers or one of the parties adopted our position and said, oh yeah. And so now we have a fight based on our footnote. But the sad part of that is we now have a ruling out there that's just possibly wrong. Now, we won't know that finally until it goes all the way up to the Wyoming Supreme Court, which it likely will, because they usually do if they're mineral producers. And so that is a perfect illustration of how inefficient this is, where we don't have the ability to catch mistakes by the parties up front, make them address everything the first time around. And then, they can always appeal. It's not like ours is the last word. We're the first word on state assessed. They always start with us and then goes to district court, and then Wyoming Supreme Court. Sometimes it jumps right to the Wyoming Supreme Court if it's a super universal question. They can ask to skip the district court, and it's called certify it straight up. But that's a perfect example of how inefficient and wasteful it is when we do that. And it's happened now at least twice. And there are 2 or 3 others where there wasn't enough at issue, but we had to drop that footnote nevertheless and say, the parties didn't get it, but because of the Solvay decision, we can't do a complete job for you. And that's really frustrating.
Follow-up then would be to answer the critics. None of us are lawyers up here, and we speak the efficiency language, but this will be attacked by the attorneys on the floor who will bring up the question that probably Representative Oakley made about introducing evidence outside of what was argued. Give us your best elevator speech to refute that argument.
Mr. Chairman, and I can't recall the fellow's name, what's it? Cheston? Yeah, I got an email from one of the legislators and he said, this is what happened, but I think we probably missed something and can you, so I sent him an explanation. He said, that's going to really help. So I'm hoping that it's made the rounds and the folks aren't going to get squirrely about how simple this really is. I think I would reduce it to simply this. The board is simply a court that has to have the ability to look at the entire law, every part of the law, whether it's a rule, a statute, a case, when the parties have failed to do so. And it's just that simple. It really is. There's nothing more to it. And I think the Solvay just, everybody goes, well, the language sure doesn't seem to make sense as to why you would need to say that. Yeah, we really did need to say it until the Solvay decision. So,
Excellent. Thank you. Any questions for Mr. Hartzog?
thank you
Sir,
so
we
much.
appreciate your time today.
Appreciate it.
Thank you. Okay, who's next? Public testimony on Senate File 55. Going once. Anybody? Anybody? Okay. Anybody on Zoom? No Zoomers today. Okay, we'll close public comment committee. What's your pleasure? Moved by Senator Pappas. Second by French. Well, gentlemen, pretty straightforward bill. Are there any amendments? Obviously, all the operative language is on page 3. Good. Questions been called? Please call the roll.
Senator French,
Aye.
Senator Ide,
Aye.
Senator McCohen,
Senator McEwen, aye.
apologies, Senator Pappas. Aye. Chairman Beitman.
Aye.
That is 5 ayes and 0 noes.
Thank you. Thank you, committee. Who wants to shepherd this bad boy on the floor? All right, I'll probably take it. Thank you. With that, this committee this meeting is adjourned. We'll see you Thursday upon noon recess. I'll have at least one bill possibly more, seeing what happens with introductions. Thank you very much.